Welcome to the UUM-MMU International Humanitarian Law Moot Friendly Match. Today, we will be having two institutions participating in this friendly match, UUM and MMU.
Before we get started, on behalf of MMU SIG Mooting, I would like to express my sincerest appreciation to all of you who generously help us to make this collaboration a success.
Ladies and gentlemen, this friendly match is organized to provide a platform for the international humanitarian law novice mooters who never had the moot experience in this field before to gain exposure to the real conduct of IHL moot competition.
Prosecution submits that Major Lydia has compelled a prisoner of war or other protected person to serve in the forces of a hostile power contrary to Article 8(2)(a) and 5 of the Roman Statute.
My first subground is that she had ordered the placement of landmines to be in a way that they would explode by the presence, proximity, or contact of a person, and this would cause injury or possible chances of death.
The defense submits that the defendant cannot be held individually criminally responsible for the alleged crime of compelling civilians and prisoner of war to serve in the hostile power forces.
Firstly, the M1984 mine was not an anti-personnel mine. Secondly, the mine is not prohibited to be used. And thirdly, the M1984 mine was not of a nature to cause force injury or unnecessary suffering and was not inherently indiscriminate.
If that's what the judge actually meant, then the judge would say yes, then you answer the question. If he said no, then the judge would clarify it for you.
So for the first prosecution, I think you started off fairly confidently, and there was a reasonable attempt on your part to try to answer questions in.
So I was quite impressed with the written submissions from the defense, honestly speaking, because the format was there. When I did mine as well, we looked at a lot of past years and I could really just see that there was a proper submission. So just be cautious and aware of time, because by ignoring the time and hoping that the judges will ignore it with you, it doesn't mean that you're getting away with it. It just means that you might get lower marks when it comes to moot. And then this is in a moot court setting.
Because there is a limit to what you can say, just understand, I think, what is the most relevant to your case, what absolutely needs to make it in.
If the facts are unclear, what you can do is perhaps maybe frame a situation and direct it to the judge and give a plausible, not in an assumption, explanation, but not in an assumption.